Well, the jury is now going to be deliberating in the Todd Kendhammer case out of Wisconsin. He is accused of beating and killing his wife, though his defense is that she was killed in a freak car accident when a pipe smashed right through the windshield after falling off of a truck. I'm here with attorney Michel Bryant. Thank you for joining me.
You bet.
So, first of all, there was some weird little lottery there where he excused two jurors. One became an alternate and one was excused. Just flesh that out. And is that typical?
Every jurisdiction does things a little differently. You know, two alternates in a trial of this length with 12 in the box is not unusual. That's pretty normal. Sometimes the two alternates go into the deliberation process, but they don't contribute. They just monitor it. They do that because if somebody gets bounced along the way, they don't have to start from scratch.
The alternate just steps right in. That's very smart. Come up all the time.
That's very efficient. A lot of them also just have the alternates standing by, which means if they do replace a sitting juror, then you do have to start over, and that's a pain.
And here we saw the defendant choose the numbers of who to excuse.
Let's see, I'll pick one out of a hat, and Joe Blow, you're out of here. The winner, you get to leave.
You've never seen that?
I've never seen that, and I've never seen where they actually, beyond that, ask the defendant, him or herself, they don't get to pick the person. They just pick two numbers randomly, and then they've scrambled them somehow, and each number reflects the name of a person.
So how do they normally do it then?
Well, normally, again, it's one of two. Either they say you're on standby and you go home, do whatever you need to do, or you're going in the jury room, but you're just an observer at this point.
But how does the judge choose who is excused? You're saying it's not typical for the defendant to do it. So I'm saying, who picks?
Well, the alternates are usually identified from day one. So going in, you're number 13 and 14. You're not officially part of the jury. You're just there just in case. So that's done through the voir dire process, and that's not a surprise. That's typical. So the real question is, what do you do with those alternates? And this judge here, and in the state, I guess, Wisconsin, they do this little mini lottery system. It's interesting.
It was really interesting, yeah. So what did you think of the prosecution's rebuttal? Because we didn't get to touch upon that.
The rebuttal
what were your takeaways?
As you know, the rebuttal is supposed to be precise and deal only with not things you forgot in your opening argument, but whatever you may have heard the defendant use to support their defense. And that's it. That's all you're supposed to talk about. So he talked a lot about clearing up some of the discrepancies he believes that defense counsel presented to this jury during their closing argument. Just little ticky-tack things for the most part about physical evidence and what the police were and weren't able to glean from their investigation. I think we still get down to the same big question on both sides of this case. For the prosecution, what they've failed to prove is why it was done, the motive. From the defense side, they're suggesting, well, why didn't the prosecution have this, and this? Why are they not able to connect up this series of random events and into a cohesive case against the defendant?
Here's how the prosecution's argument reads to me. Todd Kendhammer is a liar, therefore he's guilty of this crime. How do you prove someone's a liar? Is it possible to prove it in a case like this?
You've got so many, again, the discrepancies in some of his testimony on stand and then his statements to the police. That's an issue. That's an issue that's tough to get beyond. Things about when
inconsistent statements would support that somebody's a liar.
Exactly. I mean, either he's totally befuddled all the time, or he is definitely lying because upon reflection, he's had time to fix his story. And that never reads well with a jury. If the guy's coming off as somebody who's telling you what's convenient at the time, fixing it later, only to self-serve, that's not good. That makes you look like a liar.
So then do you think that him taking the stand and adding potentially more inconsistent statements to his story was a fatal defect for his defense team?
As I said earlier, I think that was one of the two things that sunk this ship, in my opinion. Again, do I think he's guilty?
So you think he could potentially be found guilty?
I think he could be found guilty. Do I think he's guilty? I don't know that I know enough to know that he did it or not, but that's a very different question than would a jury find him guilty.
But then how does a case like this hold up upon appeal?
There's a lot of stuff. There's a lot of stuff going on.
So what would be some of the issues that they would face?
I think they're going to have to look at some of the investigative processes and why certain things weren't further investigated. But I don't think any of that stuff, it makes nice appellate paperwork. I don't think it wins the day on appeal because there is certainly enough circumstantial evidence here for the jury to piece together all of these questions. Why was he on that road at that time? Why didn't they call about his wife not going to work, which she normally would have done? What's the deal with the windshield? Did he really have somebody that was expecting him to come and check that out? All of these weird circumstances put together, it's a totality of the circumstances kind of case. There's not one smoking gun here or smoking pipe. It's a question of whether a reasonable jury could come to the conclusion they come to, whatever it may be, based on this pile of evidence. I don't think an appeal is going to latch on to any of those things and say, well, no, that somehow led to an incorrect result, and we're going to give this guy a new trial, or we're going to reverse what this jury has done.
Is there anything that they could win upon on an appeal?
I think it's always a question of jury instructions, and I know they batted these things about yesterday pretty clearly, and the judge even today asked counsel, do you think my demeanor was appropriate when I did the instructions? Did I handle things as we had discussed? Why is he doing that? Why is he being so careful? Because that is the number one basis for an appeal and an overturning of a trial decision.
Procedural rather than substantive.
Yes.
Also very interesting is that the jurors were allowed to ask the experts questions in this case, which I found fascinating.
I like that too. I do
love that. But the judge had to approve the questions, of course.
Yeah, so an interesting little hybrid of what I've seen before, but it's very helpful to counsel too, because you start getting a sense of what jurors think is important and where you might need to fill in some holes. If they're asking your witness that you've just presented questions that you never got to, well, maybe you need to figure out a way to answer those questions for them.
Now, how about some of the testimony of the people that knew this couple the best? The prosecution dismisses it. Do you think it's significant? It
is. I did have a bit of a problem with a lot of the family members testifying about their interaction with the victim at or about the time she was injured, before she died, because that's totally irrelevant. I mean, what they can testify to, and what was important, to your point, is that 25 years together, never saw them fight, they are the perfect couple. We're shocked with any suggestion that there was anything but the perfect violence-free union here. That I'm okay with, and I think that has merit. But to let them go into, their crime because their mom is dying, and that's irrelevant.
Yeah.
I don't know why the defense let them get away with that, but it helps the prosecution.
Now let's listen to some of that testimony from Todd Kendhammer's son-in-law about just how perfect this couple was. Welcome back to the Law&Crime Network. We're having some technical difficulties with the audio on that clip, but basically I'm here with Michael Bryant, and we'll just summarize it.
Okay. How's your microphone? Your microphone's working?
I think my mic, yes, testing 1, 2. So that was just the son-in-law of Todd Kendhammer talking about how perfect everything is in the relationship.
Dream relationship.
The outside perception, right? What I wanted to talk to you about is you said that there could have been a domestic abuse situation here, and you think maybe some people on the jury were chosen because they have an experience with domestic abuse?
You know, I don't know about that as much as the fact that we look at the jury makeup now as they're going into deliberation. You have 10 women, 2 men. I mean, if you look at national statistics, there's a chance, a pretty good one, that of those 10 women, they either know of a domestic abuse victim, if not having suffered some of it themselves. We're in a remote area in Wisconsin where maybe people are less likely to speak up. We have a couple that's been married 25 years. Maybe they're hesitant to share this kind of shameful scenario. She's afraid, he's controlling. We haven't seen that kind of evidence. We've seen what we just saw there with that particular witness, which is perfect domestic relationship. But we don't know. We just don't know. So what I'm saying is, as you get into that jury room and start deliberating, the jury is allowed to bring their own personal life experiences into the process.
Right.
And if you have people with some sort of experience with domestic abuse as victim, counselor, friend, that may play into their deliberations in determining what the relationship really was. Not what we hear it was, but what it really was and what might have led to a beating that would end in this woman's death.
And that's something that obviously can't be avoided.
Oh, no.
Though the judge will warn against doing such a thing and encourage the jurors to make a determination based on the instructions of the law.
And the evidence. And they could take the evidence as we've seen it and come to those conclusions that that she had so many injuries that I don't think any of the experts explained away all of them. It's like 50 injuries of some sort or another. Nobody explained away all of those injuries. Mm-hmm. So the jury can look at that and say, well, you know, maybe there was something more there that we're just unaware of.
Right. Though it could also have been from a car accident because we don't know how the car accident unfolded.
No,
so either explanation could work.
The accident itself, you know, it's not a traditional car accident like 2 big pieces of metal colliding.
Right.
This is a pretty singular, isolated event if you believe the defendant's story that the one pipe came through, and even if a mug was flying around and some fists were flying, that's very different than a 2-car collision.
And so how difficult then is it for the experts to effectively analyze something that doesn't happen very often?
Yeah, I think they could have done much better. There's no doubt about it. When you have the defense expert saying, and there was a quote that I couldn't believe when he actually said, first of all, I don't think the pipe came off a truck and through the windshield. This is the defense expert. Not only being vague about the defendant's position, but contradicting it.
Yeah.
So your question's a good one. Isn't there something an expert can do? Yes. Did he do it in this case? No.
And so whose fault was that? Is that
well,
just
that's
a
the
lack
attorney's
of preparation?
problem. That's the attorney takes the hit for that, because
Yeah.
you better have an expert that's either so good that doesn't need your direction, or you've given sufficient direction. But this is elementary stuff. If you're saying something that contradicts the defendant's position, what do we need you for?
Yeah, exactly. But how typical is it, I'm wondering, to try to make these inferences that because something is so perfect or because something appears one way, it's really the opposite? Is that typical in a trial?
You know, there's a lot of holes in this case. We know that. It's very thin on a lot of levels. And so...
Because I'm wondering how dangerous that ground is, just to start making those opposing inferences where you perceive something one way and you're telling jurors that it wasn't really that way just because it seems so perfect. Not because there's evidence that supports the fact that things weren't as they seemed.
And it gets us back to the same analysis, like, well, what else happened? And what could it have been but for something this defendant did directly to the victim?
But as you said, it leads the jurors' minds to wander, and then they start bringing in their personal experiences, and doesn't that get a little bit dicey?
It does, and then when you talk about appeal, you can't really invade those parts of the process. You know, if you went to each juror afterwards and you got a declaration as to what they thought and felt and what happened during the course of the deliberations, most of that is going to be respected by a trial court. There has to be some total abuse or misconduct by a jury member.
Right. So you can lead the jurors to believe something, And what you're saying is it wouldn't be grounds for an appeal just because they believe it.
The jury's mind is sacrosanct, and unless they are somehow misconduct oriented, they've tried to muscle another juror to think their way, not convince them, but threaten them. It has to be pretty extreme.
But Michael, isn't it one thing to say domestic abuse was going on such and such date, and even though we don't know for sure that that's what was happening behind the scenes, look at all these other instances leading up to that, to a murder. So such and such person was arrested on this date for beating the wife, threatened her on this date. That all supports that, yeah, maybe on that occasion where someone was killed, the person killed him or her because there was a history of domestic abuse.
Of course,
abuse,
that's
right?
easy. That's
that's easy. And in that circumstance, you can say, well, even though Witness 1 and Witness 2 says everything was rosy, obviously it wasn't, because we have this trail of evidence showing that even though they put on this act, that they had the perfect family, the perfect home, the perfect life, these reports show that in fact that wasn't the case.
Yeah,
but here we don't have
that.
We
don't.
We have everything is perfect. We have no evidence to the contrary, but we're telling you things just are never that perfect, and it couldn't possibly be.
It's a little Stepford Wives-like,
right.
Because 25 years of marriage, they never argued. They never. What it tells us is people aren't monitoring them every day of their lives. I mean, because it's not practical. It's not likely. So it's just as unbelievable to say we never, ever, ever have had a crossword or an argument as it is to believe that it happened every single day. I mean, the reality is somewhere in between.
Yeah, exactly. And so we're going to toss in a second to Kendhammer's testimony. What do you think people should try to focus in on when they're listening to this testimony? What do you think is the strongest element of it for the defense and the strongest element for the prosecution?
His demeanor is key. I mean, just how he presents himself. He's a pretty mild-mannered guy. He's not really forceful character. He may be simmering underneath, but how he presents himself is pretty darn calm. So I would look at that.
Much like yourself.
It's almost too matter of fact if you think about it. He does get emotional at a certain point, but a lot of it is very matter of fact. So is he rehearsed? Kind of check that out. Does it feel like he's rehearsed? And then when he's pressed on cross, he definitely gets a little more flustered and it starts to make a little less sense. So pluses for the prosecution, it's just how he's inconsistent and somewhat robotic sometimes in his answers. And best for the defense is when he does get a little looser and seem a little more like a human being. That's more helpful.
Okay, perfect. Let's take a look.
And